did want to begin by saying I'm probably just going to briefly touch on sufficiency at the end of my argument and start on the second argument.
So what he basically said was, I'm not going to start with the evidence. I'm going to start with something else first. Man, let's get on with it.
I'm going to touch on the facts briefly of what occurred. This is a murder case that involved a conspiracy and a murder incident. And just touching on the facts of the murder incident, this case involves Adolph Thornton, who is a well-known music artist, who was shot by two individuals at a cookie store in Memphis. This shooting was captured on video, both outside the store and inside the store, and showed a full depiction of what occurred.
So this is the Justin Johnson murder appeal, which actually we're going to deep dive into why it was actually denied, because the tale of it all is very telling. But before we do, hit that QR code and tap that link in the description. Get paid in this goddamn crazy Wednesday. You going to get about $500 if you keep on playing every day. That's a little extra income that you all want. QR code and link in the description. That's free cash, $5 for setting there as soon as you will start that app on your phone and get to playing. Number 2. In the Apple Store. Number 3, in the Google Play Store. For a reason, read the reviews before you download, then get in, get to gaming, get to playing, and get to getting paid. Sounds good? Good. So it gets denied, but it's kind of interesting as to how it all goes. Roll it.
It almost seems to contradict some of what I believe the court ruled on. I believe the court made a finding that that his body was in essence in the photo, Exhibit 35, how it was at the crime scene. But in the video, it showed the defendant falling on his stomach halfway out the window. And in the photograph that was introduced that we're making this issue on, he's on his belly completely inside the store.
Was that explained in the proof?
I think there may have been, and I was looking for this in the record and couldn't get to this, that a paramedic or his brother was present with him, may have moved the body, and that might explain that, and I do need to touch on that. But as far as just giving an accurate depiction of the actual murder, the video is much more probative. It shows the body, if the body was moved by a paramedic or was moved by his brother, the video shows a more accurate depiction of where his body fell. And, the video shows how many gunshots were fired and does it in a much less unfairly prejudicial way.
Explain that to me, why the video that shows all the things you referred to is much less prejudicial than a single photo.
So the video, in the video, of the exterior video of Exhibit 5, you see the victim be shot and fall through the window. You don't get the close-ups of the wounds, and the wounds I felt were very gruesome and gory. And when I think of what was missing in the photo, in the video that you get in the photo, is kind of gore. He has, in the Exhibit 35, the photograph, he has a large, pronounced gunshot wound to the cheek. He has what appears to be an entrance and exit wound on his wrist. His torso is very shot. It's very blood-soaked. Just to be frank, it was a very disturbing photo. Whereas in the video, he falls over, as I said, stomach first through the window. There isn't as much bleeding because of how quickly the incident occurs. I don't remember seeing any large exit wounds, any exposed flesh, all of which you get in Exhibit 35.
I'm looking at 35, and I also see evidence markers on the ground. I see 51 and 52, and then partially I can see it looks like 53. I believe the prosecutor below mentioned shell casings. I don't want to speculate, but do we have any indication what these evidence markers were and what their significance was?
It could possibly be shell casings. I don't remember at this time what those were. There were a lot of shell casings because there were 2 guns used and a lot of rounds were fired. But I don't remember what those placards specifically.
Would that be important if there were shell casings inside where the victim's body was?
Yes, and they may have admitted photos of where the shell casings were with the victim's body removed. I see that in a lot of cases. I don't remember if that occurred in this case. I think what is really important is if the victim's body was moved, which just looking between Exhibit 5 and Exhibit 35, it did seem that at some point it would have had to be moved by a paramedic or his brother trying to render first aid. Then the probative value, I just don't see it.
So no real facts, just shit like this.
He doesn't get to sit with his attorney. There's going to be a barrier in communication. And anytime he wants to speak to his attorney or suggest a question for a witness, the attorney has to turn his head away from the witness. And I think defense counsel touched on this in the record.
That follows up and get destroyed by shit like this.
Is that fairly common practice in Shelby County, or was that unique to this case?
It's somewhat common.
So make your final case, because I'm about sick of you.
Argument was the court, or firstly the state, did not charge Hernandez Govan, who was the alleged sort of centerfold of the conspiracy in this case. The court issued a missing witness instruction that would allow the jury to potentially draw an inference that his testimony may not have been favorable to the state. The state, in their closing argument, sort of turned this on its head, and instead of addressing on the missing witness instruction, made this a Fifth Amendment issue, pretty much insinuating Mr. Govan would have certainly asserted his Fifth Amendment right not to testify, and sort of drew the jury's attention away from that missing witness instruction. Importantly, too, there was no proof in the trial that Govan would have asserted his Fifth Amendment right to remain silent. He very well could have testified. He did have a proffer agreement in place with the state and had spoken to them freely previously. They also called 2 witnesses to this case who were co-defendants. The other Mr. Johnson and Cornelius Smith, and there was one other witness, I believe, that was facing separate criminal charges who was called as a witness. In light of the circumstances, I think this is totally improper, that this is proof that's not in the record. It contradicts what the state's been doing throughout the legal proceeding. The court didn't take any curative measures. I probably should take a step back. Defense counsel did not object to this. We're addressing this under plain error.
So when did the state make this argument? Was that in their initial or their rebuttal closing argument? I'm just curious.
I'm not sure. I believe it was in the initial. I don't think I put that in my brief.
Also, I haven't looked at the whole record, but did the trial court instruct the jury before or after they argued? What I'm getting at was the prosecutor responding to this, or was it anticipatory response?
I believe it was responding, and I could be wrong. I believe the court would have instructed potentially prior to closing. That was my recollection of it, but I could be wrong about that. And I believe it was responding. My recollection, like I said, I could be wrong, was that the jury had already been instructed as to missing witness, and that the court and that the prosecutor was in essence responding to something that had already been instructed.
Was he missing?
So he was a state's witness with a proffer agreement that I do not believe defense counsel had called, and I do not believe the state had called.
So he had been listed on the. I'm sorry, Judge.
They had what? What was that last part? I couldn't hear.
That the state had not called nor the defense,
gotcha.
And
Okay.
I think the argument was he was available to the state but not available to the defense.
Why would he have been available to one and not the other? Could defense not have subpoenaed him?
They could have. I didn't do a ton of research on that issue since it was instructed.
He was in custody, I guess, is my point.
No, he was out of custody,
He was
I
out?
believe. Yes.
Okay.
My understanding was he was out of custody throughout the entire legal proceeding.
Was he listed on the indictment as a witness for the state?
So I believe he was listed in the indictment as a defendant, and I could be wrong. So I believe he's on the indictment as a...
Yeah, he was a charged co-defendant.
Well, he was charged. I thought you said earlier that he was uncharged.
He was charged, and he had a proffer agreement in place with the state.
You see your minute.
Oh, yes. And then if I could touch briefly on sufficiency, I'll keep it in like 30 seconds. My main point on sufficiency is in the brief was in regards to the conspiracy, that there had been no meeting between my client Hernandez Govan to form that conspiracy to commit the murder. I think that also may have tied into why he was not called. And if there's no further questions, I would ask the court to reverse my client's convictions.
Thank you, sir.
Thank you.
They couldn't flip Hernandez Govan because he would have literally had to have certain charges dropped and then became a witness. The same way like Justin Johnson's brother got did. So unless they were willing to drop the charges and then Hernandez Govan flips, why the hell would he go in there and say anything? Nigga, I got next. That's like asking somebody who about to play basketball and they like, yeah, I got my team over here. And you like, all right, bro, come rock with my team real quick and then go play with your team. The whole time you're studying what the hell they gonna say. I can tell you 100% he was gonna plead the fifth. He would have went on that stand and said, I plead the fifth. What's your name? I plead the fifth. Because what do they say that's for? So that you don't put yourself in a trick bag for future shit that can be used against you. Future for this, meaning he had next. So let's get on with the prosecution side, who I'm going to say just came in, started whooping ass, and revealed something that we're going to make another video. I won't even play that part. We'll make another video because something gets identified, but it deserves its own video because somebody called this a week ago and it just got exposed as to something about something. Don't worry, though. Let's go.
I mean, having practiced there, I know the deputies are very concerned of being able to intervene if there was some issue. There's that space. I know in my practice, when I've had this issue raised, the deputies are wanting to be able to intervene if there's some issue before anything can happen. And but it's not clear in this record. The defense counsel did not seek to subpoena him to show that they had no ability to get him there. They just made the reference that I can't force him to testify. Well, neither can the state. Every defendant has a Fifth Amendment right not to testify. And the court did grant the instruction upon the defense request. The instructions were given before closing arguments. And my memory serves me that the state did not really address this issue at all in its opening close. The defense counsel addressed it at length in its close. The final issue raised by the defense was in regards to the conspiracy. The defense on my friend on the other side focused solely on that his client did not participate in the initial meetings between Mr. Govan and Mr. Mims, who's also known as Juke. And it's confusing through the record because it doesn't mention what his real name was, Anthony Mims. And he's referred to as Big Juke or Juke throughout the entire thing. And you find out at the very end it was Anthony Mims. But Anthony Mims and Hernandez Govan were the ones that had put out the hit, $100,000. And they met with Mr. Smith, Cornelius Smith, who was the co-defendant who cooperated and accomplice testified, who was one of the shooters actually at the scene. However, if you look at Patel and the chain of conspiracy, he doesn't have to participate in every conversation. He doesn't have to participate and know exactly all the individuals involved. However, the evidence is clear about the conspiracy. So Mr. Cornelius Smith testified throughout the trial about the meetings, about being introduced to the defendant, Mr. Johnson, and by Mr. Govan, and that, I believe, were Mr. Juke, Mr. Smith, Mims, and that they met, and then subsequently to being introduced to partake in this criminal conspiracy, which they agreed to split the $100,000 and give $10,000 apiece to Mr. Govan for putting them together for this hit. That Mr. Smith testified that he and the defendant met multiple times after that to discuss and plan out how to do this and when to do this. But don't leave it just on Mr. Smith. The defendant, on the night before, the day before the homicide, communicated with the next individual involved, Treon Ingram. He did not testify, but there are cell records between the defendant and Treon Ingram coordinating getting the white Mercedes that was later used in the homicide. You can actually see it on the videos, both at the homicide scene. And then you have the testimony of Mr. Kristen Garner, who testified that he was with Mr. Ingram when they delivered the car to the defendant. This was 3 a.m. the morning of the homicide, and that there was an assault rifle and pistols in the car at that time. And he testified at trial. But don't leave it on to just Mr. The Kristen Garner the defendant's own cell phone records and the videos from crosstown apartments where the defendant lives, as well as the Valero gas station, and the defendant's cell phone records show that he was at those locations and met those when those events occurred, and that he had the white Mercedes back at crosstown apartment. But so you have those things connecting him, and the defendant even texted Hernandez Govan's street to where the Mercedes was later found to Mr. Ingram. So the connections are all there, showing circumstantially there was an agreement and that the defendant actively participated in it. But don't leave it there. Again, back to the Mr. Smith's own testimony. He testified that the defendant called him the morning of the shooting about 11:30, 12. It's in the briefs and in the record. That morning, the defendant's own cell phone showed that he called Cornelius Smith that morning, and that the defendant's own cell phone records show that he went and picked up Cornelius Smith and drove him to the scene. All that shows a detailed level of the accord, the agreement.
What ends up happening? Well, today we get the conclusion.
Convicted of killing Memphis rapper Young Dolph has lost his appeal to overturn his 2024 guilty verdict.
Justin Johnson was convicted of first-degree murder and sentenced to life plus 35 years. His legal team appealed, claiming there was insufficient evidence and multiple errors were made during his trial. Yesterday, the Tennessee Court of Criminal Appeals upheld the lower court's decision. Johnson was one of the men who shot and killed Young Dolph in November 2021. The other gunman, Cornelius Smith, has a plea agreement under review.
The arguments were about technicality. The arguments were not about actual real evidence. The whole entire premise of the man's argument was a couple of things. The first one, Young Dolph photos were prejudicial because the video would have worked. Stupid, because that actually happens a lot. They showed the autopsy, you know what I'm saying? Same shit. All right. So you're saying that by them looking at those photos, they had to find somebody guilty and somebody is in the courtroom. Oh, Justin Johnson is sitting behind the damn counsel for him, his own lawyers. Oh, his lawyer had to turn around to hear Justin Johnson's input on questions that he should ask a witness and all of this shit. Oh, the other people who were involved in this, they already came in to testify and all this shit. Yeah, they all had deals. Justin Johnson's brother, Jamarcus, had a deal. Goddamn, what's cuz name? Cornbread had a deal. What the hell? So when he says that shit, you already lost. You didn't argue no facts about the real case. You argued technicalities, which rarely win. Some of the technicalities had to be brazen, such as Brady violations, which means withholding evidence. Justin Johnson got a chin up, chest out. You killed Young Dolph. Suck this shit up. Spend the rest of your life in prison. Die like the hoe you is. Justin Johnson is the definition of a street bitch. Because when posed with the task to fight people when he got jumped, instead of getting your crew, he went and shot up a bowling alley. When a girl told him, you got to get the hell out, you can't have sex with me no more, he pulled a gun on her and took it from her anyways. And then shot at the house to try to scare her into doing shit. But your bitch ass decided to turn yourself into the police. When it came for Young Dolph to be killed, to show you the third strike, which means he's a bitch, he wasn't the first one out the car. That was Cornelius Smith. So in order for him to kind of look good, oh, he decided he wanted to run out afterwards and then start shooting. Yeah, 3 strikes and you out. Don't drop the soap. Subscribe, turn that bell, stay notified, and share to keep your people aware. We are 24K away from this giveaway and this giveaway. Man, y'all check out this crazy ass video of how Charlemagne over-explained himself when he shouldn't have. Click right here to find out about that, or click right here for the playlist, and I'll catch you on the next one.